got three cases involving the same defendant, State versus Matthew Murphy. Case number 20, CR 207, 20 CR 267, 21 CR 089. You are Matthew Murphy?
Yes, sir.
All right, Mr. Murphy is heard by video from the Justice Center's first pre-trial. His attorney is Dennis Kirk. He is present in the courtroom. Also present in the courtroom is Assistant Prosecutor King. The defendant is charged in 20 CR 207 with taking stolen property, and I believe that is set for final pre-trial on September 1 and the trial on October 12. And 20 CR 267 is 4 counts, 2 counts of all involving possession of drugs, methamphetamine and others. And that case is set for trial on, let's see. Another week we set, also set for October 12. And then 21 CR 89 is the failure to appear, and that's set on the same time. All right. Now, the discovery complete in all of the cases.
It is from the state, Your Honor.
So I've received it all from the state, Your Honor. I'm in the newest case, the 89. I know I haven't filed anything yet. I think I filed in the other cases.
Yes, you did. All right. And no pre-trial motions.
No, the only thing I would raise would be, I don't know if it's a conflict or not, the victim in the 207 case for shooting stolen property, I provided representation to her a couple years ago in municipal court. So, I mean, the state and I talked about that. I want to make sure it was on the record. I'm not sure that I learned anything from that representation that would be problematic, but I wanted it on the record.
Sure. Well, I mean, in that case, it's complete over with, and it's nothing in that representation would be able to be used, and I will see a conflict. If I can find out anything different, at this point, I don't think I'm facing this. And those five people.
Okay.
All right, or withdrawal, I should say. All right. And you say that then written layout was provided?
Yes, sir.
Okay.
And I have relayed that to my client.
All right. Anything else in coming before the court regarding this case?
No, Your Honor.
All right. We'll see you then on September the 1st. Mr. Murphy, thank you. Okay. All right. Lacey Hensley.
I approach Your Honor.
All right. We have 2 cases involving this defendant. Case number 19 CR 124 and 21 CR 080, both out of the state of Ohio. This is Lacey Lynn Henry, present on behalf of the state for cases. This is Assistant Prosecutor King. President on behalf of the defendant, Attorney Dennis Kirk. Are you Lacey Lynn Hensley?
Yes, sir.
All right, and case number 19 CR 124, the defendant was convicted of possession of heroin, a 5th degree felony, and put on community control on August 20, 2020. Then on July 13, there was a notification of violations alleged to have been filed, and the court Mr. Kirk represented her, and we had a definition hearing set, and then continued because the trial. Now the newer charge. The case 21 CR 80, the defendant is charged with soliciting to assault assault on a peace officer. And obstructing justice, fourth and third degree felony. That matter is set for trial on September 23rd, and a final retrial on August 25th. Right? Now, Ms. Hensley, I've been presented with a plea of guilty in the new case, 21 CR8. And it indicates that you are going to withdraw your not guilty plea and plead guilty to obstructing justice under 29.31.32A2, powered by Code 33 felony. That is count 2 of the indictment. The plea form says count 1, but that's actually count 2. Change that. All right. It says you further understand. Well, first of all, let me ask you, this is a 3-page form that the prosecutor's office prepares and submits to the bench. And did you go over this agreement with your attorney before you signed it?
Yes, sir.
When did you sign this agreement?
Yesterday?
Were you correct? Did you have to sign it?
Yes.
Was Mr. Kirk there with you to go over with you and explain it to you?
Yes, sir.
And he answered all your questions?
Yes.
And when you signed it, did you understand it's an agreement to plead guilty, which means it won't be a trial, and next step in this case will be a sentencing hearing?
Yes.
And you feel you had enough time to fully consider this matter for making this decision?
Yes.
And this is still what you want to do?
Yes.
Right? And you're entering into this agreement to plead guilty voluntarily?
Yes.
Okay, now, going back to page 1 of the form, it says that you understand maximum prison term for that is 36 months. The minimum the prison term is imposed is 9 months. And there's different increments in between. It goes up to 12 months, and then after that, every 6 months, up to 36 months. And there's a fine available of $10,000. Do you understand that?
Yes.
Are you facing any felony charges in any other jurisdiction?
I have a PV in Montgomery County,
You have a what?
a PV in Montgomery
Or
County.
a felony?
It's the same charges that I had years ago, and I got community control along with that.
Right.
But I guess the new charge would be a PV, because they put out a
Okay.
previous warrant for me, but that's it.
So you're on probation in that county. And then you're also on probation in the other case we have here, the 19 CR 124 case for possession of heroin.
Yes.
Now, if you are convicted of this offense, then that is a violation of your community control 19 CR 124. You have to charge it because you have to be convicted. But regardless of what happened with those allegations, if you're convicted of a felony, it's automatically a violation of your community control in the possession of heroin case in this court. You understand that?
Yes.
And if you're sentenced to prison in both cases, and if you're sentenced to prison for Montgomery County, all of those sentences can be ordered to serve consecutively, meaning one after the other. You understand that?
Yes.
Now, under the law, if you are convicted of this offense of obstructing justice, a third-degree felony, and sentenced to prison, once you complete the prison term that's been imposed by the court, the adult control authority under the sentencing law would have the right, if they decided to do it, to put you under post-release control supervision for a period of up to 3 years. It's optional, not mandatory, but they make the decisions on the judge. If they do that, that means you'll be supervised on the terms that they specify. And if they decide that you have not complied, then they can return you to prison even though you serve the entire prison term set by the court for an additional period of up to 9 months for any one violation, although there is a cap or limit of half of whatever term was imposed by the court for all violations. But if you commit a new felony, then in addition to whatever sentence the judge in a new case imposed upon you, that judge can also sentence you, in this case, to an additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. You understand that?
Yes, sir.
Now, I'm not required to sentence you to prison for this offense. I can impose community control, which means probation. And by do that, you'll be put under the supervision of a probation officer for a period of up to 5 years under the term set by the court. If during that period of time that you're under supervision, the probation department feels you're not complying, they will file a written notice of that with the court, and you will be provided an attorney and a hearing. And if the outcome of that hearing is that you have failed to comply, then at that time the court can revoke your community control, then sentence you to prison for 36 months and fine you $10,000. You understand that?
Yes, sir.
Right now, the charge in count 2 alleges that on or about April 2, 2021 in Highland County, Ohio, you did with purpose to hinder the discovery, apprehension, prosecution, conviction, or punishment of Jordan McCracken for a crime or to assist another defendant in the commission of a crime. And I'm going to leave out all the part about the language. I don't know why you guys put all this in here. It's not a bunch of stuff that doesn't apply about being a child. Did provide Jordan McCracken with money, transportation, a weapon, or a disguise, or other means of avoiding discovery or apprehension. The crime committed by Jordan McCracken was a felony of first degree in violation of section 2921.32A2 of the Ohio Revised Code. Okay. Now, I have a question. Is this related to count 1?
No,
Okay, it's not got anything to do with count 1.
well, when you say relating, we get,
Well, count 1 is a fourth degree felony. Was Mr. McCracken charged with a first degree felony?
yes, he's already pled guilty. So,
Okay, but I'm just going to count 2. What was the first degree felony Mr. McCracken was charged with?
for his assault on a police officer.
Okay, all right, so that wasn't in this case. All right. Okay, I see this was filed separately. Okay, gotcha. Okay. Now, do you understand what it is the state said you did in that case and what, when, where, and how they alleged that you did it?
Yes.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses might try to raise a trial, and possible outcomes of the trial with your attorney?
Yes.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No, sir.
Have any threats been made to make you plead guilty here today?
No, sir.
Now, on page 2, there are 2 lines that are printed in bold and underlined, actually just a little bit over, goes into the 3rd line shortly. And it reads as follows: the defendant shall enter plea guilty to count 2, state will dismiss count 1, state defense jointly recommend community control, and defendant be referred to the drug court. That's your understanding of the agreement?
Yes, sir.
Yeah, I don't promise you anything other than that to get you to plead guilty here today.
No.
Under the law, the matter of sentence is up to the judge, not to the parties. So even though there's a recommendation she get community control or probation and be put in the drug court, the court, the judge, is one that makes that decision. So once I've heard, if you plead guilty, once I've heard all the information that's presented, I could decide that community control isn't appropriate sentence, that you should be sentenced to prison in this case, is also in your other case for violating community control in that case. You understand that?
Yes.
And likewise, in the drug court, there's a referral to the drug court. There's a process you have to go through. I don't know if you met with Mrs. Sherwood yet?
Yes, sir.
Okay. And so she probably explained that to you, but that is something that I don't order people to go to drug court. We refer them, and then they have to decide whether or not they want to apply. You put in the drug court, and even if you apply, I don't have to accept you if I decide that you're not an appropriate candidate for that, even to meet the clinical criteria. And I do have to decide to meet legal criteria. You understand that?
Yes, sir.
And the state's consulted with the victim in count 1, and that officers agree with this?
Yes, sir.
Secondly, do you hold any license or certifications from any state government agency or commission for any kind of occupation or profession?
No, sir.
Right, now you have certain rights you have to understand before I can accept plea guilty from you in this case. First of all, you have the right to have counsel. Mr. Kirk was appointed to represent you since you could not afford to hire an attorney. Now, he wasn't appointed simply to try to work the case out, but provide any defense that could be available to you under the law that provide. So if you decide you don't want to do this, that you want to defend the case, then he'll continue to represent you, including a trial, if that's what you want. You understand that? And under the Constitution, essentially, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens from this county who are summoned for jury duty on their trial day. After those 12 are selected, the evidence would be presented, they'd be instructed on the law, and then they would decide by unanimous verdict, meaning all 12 of them would have to agree as to whether or not the state proves you guilty of this charge. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, and waive means to give up your right to have a jury trial, and then in that case, you would have what's called a court or bench trial, meaning instead of the jury hearing the evidence, it would be the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt by proof beyond proof of that. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking you questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that?
Yes,
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to testify for you, same as the state. So, if you have witnesses you're not certain are going to come in voluntarily, at your request, the court will issue a court order, which is called a subpoena. That would force those people to come to court to be able to testify, even though they didn't want to, which is the same way that the state's witnesses are required to come to court. You understand that?
yes,
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one's even allowed to comment about it, except in one situation. If there's a jury trial, you don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
yes,
And under the Constitution, you have a presumption of innocence, which means that you are presumed innocent until proved guilty by the state of Ohio on every essential element of the offense charge. So the burden is on you to try to show you're not guilty simply because you've been indicted and accused. In fact, under the law, you don't have to present any evidence in your defense or trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio. Prove your guilt, prove beyond a reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
yes,
Now, originally entered plea of not guilty. No guilty plea denied the allegations of the indictment, denied the constituted crime, and that plea exercised or revoked all the rights that I just described. You change your plea from not guilty to guilty, that is the opposite of not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you're the one who committed that crime. And that plea Wage gives up all the rights I've explained for you today, except your right to have an attorney, which you always have, no matter what your plea, with that exception. Your plea of guilty. Wage gives up the right to have a jury or court trial. Wage gives up the right to confront witnesses against you and cross-examine through your attorney. Wage gives up the right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. The wage gives up your privilege against self-incrimination because you're saying you're guilty, that's what you find you guilty. And the wage gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, wage gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if I sent you the maximum sentence under certain circumstances, you could file an appeal that would have to be filed in 30 days from sentencing entry being filed. You understand all that?
yes, sir.
I was just looking at the pre-sentence report while I was reading, trying to multitask, and I think you were granted intervention in lieu of conviction in that case in Montgomery County, I believe, originally. And it said there was a hearing scheduled on 6/12/20 to revoke it, but it wasn't, as reinstated. So basically, conviction while you're under intervention, it's kind of like being on probation. You could result in being convicted. It's just so you understand that. So that's the status of your case, okay? All right. Now, do you have any questions about the charge or the possible penalties?
No, sir.
You understand it? Any questions about the plea agreement?
No,
You understand that?
yes,
You understand that I'm not bound by the recommendation that once I've looked at this case and listened to everything, they decide you should go to prison for up to 36 months in this case, and 12 months on the case that you're on probation for now. You understand that? Do you have any questions about the constitutional rights of the complaint? You understand those? Do you have any questions about the plea of guilty, what it will mean, or what will happen if you enter that plea here today?
No.
You understand that? Is there anything else you'd like to speak to your attorney about before we go any further?
No.
Do you have any questions about anything that I've explained to you here today? Then is it your decision, Ms. Hensley, to withdraw your not guilty plea, plead guilty to count 2 of the indictment of obstructing justice pursuant to the terms of this plea agreement that I've just gone over with you?
Yes, sir.
Okay, then as to the charge, and I'll just read the applicable part. Count 2, which reads, in on or about April 2, 2021, Highland County, Ohio, you did with purpose to enter the discovery, apprehension, prosecution, conviction, or punishment of Jordan Crackman for crime or assist another to benefit from the commission of crime. Did provide Jordan Crackman with money, transportation, a weapon, a disguise, or other means of avoiding discovery or apprehension, and the crime committed by Jordan Crackman was a felony of the first degree, a violation of section 2921.32A2, the charge of obstructing justice, a third degree felony, carrying a possible term of imprisonment of between 9 and 36 months in the increments provided by law, and a fine of $10,000. Also, resulting in a violation of your control in case number 19 CR 124 in this case, and probably in the intervention blue case in Montgomery County, which could subject you to prison in both cases. How do you plead?
Okay.
Okay, be seated. All right, the court finds on this day in open court, the defendant provides all the constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Rule 11. Please accept it and order filed. Defendant is found guilty of count 2, third degree felony, as set forth therein. Count 1 is dismissed. The court will order a pre-sentence investigation. Bond will be continued. It will also include substance use disorder assessment as well as assessment for mental health. Case is referred to drug court docket. That'll be set for sentencing. Okay. September 22nd, 1 o'clock. The probation officer will never be in touch with you about that. Now, with regard to case number 19 CR 124, the court will find that defendant has violated condition 1 of the 8/20/20 entry by pleading guilty in 21 CR 80, and will set hearing disposition on September at the same time, September 22, 1 p.m. And regarding the other violations, Mr. President, familiar with those, and decline admitting and denying those as well.
I did meet with her to go over those violations, and she is prepared to admit to those violations.
All right, you remember those violations?
Yes, sir.
All right, you understand you have a right on those violations. You don't have a right on the hearing, until hearing on the question of whether or not you're convicted. It doesn't just happen, I know, so I can take additional notes of that. for purposes of the other case, but you would have the right to have a hearing to cross-examine witnesses, present evidence your own defense as those allegations. You understand that?
Yes, sir.
Okay. All right. And you understand that, as I explained to you before, so if you're in violation, could go to control and sentence you to prison 12 months in this case, but I decided to do that. You understand that?
Yes, sir.
All right, so with that in mind, are you admitting to all of the violations?
Yes, sir.
Okay. All right, for Lynn time, she's admitted to those as well. And again, this position will be on September the 20th and, or let's say 22nd. Yeah, I said on the other one, September 22nd. On the case. Yeah, September 22 at 1 p.m. All right, anything further, counsel?
There you are.
There you are.
Thank you. Melanie, go on.
Don't believe her attorneys.
Oh, I'm sorry. All right, I thought it was her. Your attorney. I'm sorry, wait. You are Mr. Swisher?
I am.
All right, Brad Swisher.
Now, approach your line.
You may. Case number 21 CR 87, State of Ohio versus Brett Swisher. Present for the state, prosecuting attorney King. Present for the defendant, attorney Dennis Kirk. And you are Brett R. Swisher.
Yes, sir.
Now, Mr. Swisher is charged with 6 counts, like 3 counts of trafficking methamphetamine, 3 counts of possession of methamphetamine. I believe this is a final pre-trial. Trial is set for September 23rd. Now, I received a plea of guilty form, Mr. Swisher, which indicates that you're going to withdraw your not guilty plea, plead guilty to counts 1 and 5. And before we go through that, this is a 3-page document that was prepared by the prosecutor's office. And on page 3 there are signature lines. I'm looking at a sentence that says, "I enter the plea voluntarily," and I wrote that signature, Brett Swisher. And did you sign this document I'm looking at?
Yes, Your Honor.
And when did you sign it?
Just a few minutes ago.
Did you go over with your attorney before you signed it?
Yes, sir.
Did he explain all the terms to you?
Yes, sir.
You understood when you signed it, it's agreed to be guilty to 2 counts, and that means it won't be a trial. The next case will be a sentencing hearing.
Yes, sir.
Was this something that you had talked with him about before today?
Yes, Your Honor.
So when you came here today, is this what you expected would happen?
Yes, Your Honor.
You know, that you've had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
Or are you entering into the agreement to plead guilty voluntarily?
Yes, Your Honor.
Now, the agreement says that you're going to plead guilty to counts 1 and 5 under 2925.0381, the Ohio Revised Code, and it does refer to 3 felonies. It further states on page 1, that you understand that the maximum penalty for that could be 36 months on each in prison. If the prison term imposed could be a minimum of 9 months, and then there are different levels in between. There's a fine available of up to $10,000 in each case. There is a mandatory fine in each case of $5,000. And there's also a possible license suspension for each of 6 months to 5 years. Do you understand that?
Yes, Your Honor.
All right, now, under the law, if you're convicted of both of these offenses, then and sentenced to prison, those sentences will be served consecutively, maybe one after the other. So that could be as much as 36 months in each count, or a total of 72 months, and a fine of $20,000. You understand that?
Yes, Your Honor.
Now, are you facing any felony charges in any other jurisdiction?
No, Your Honor.
Are you currently on felony probation, parole, community control, or post-release control for any jurisdiction?
Yes, Your Honor. Warren County.
For what?
Possession, and I'm at community-based correctional facility now.
Okay, you're there now?
Yes.
Okay. And, so you're on, community control, I assume?
Yes.
And, what, degree is that?
Yes,
That's
I'm felony 3.
also felony 3. Okay. Now, if you're, and I don't know when that was committed, but potentially it could be a violation of community control, if you went prison these, that court could send you to prison and make it consecutive to the sentence that you received in these cases. You understand that?
Yes, Your Honor.
All right. Now, and nothing else other than that one?
No, Your Honor.
All right. Now, under the law, I'm not required to send you to prison. I could impose what's called community control or probation, like you have in Warren County. And that means that you would be put under the supervision of a probation officer for a period of up to 5 years under the term set by the court. And if during that period of time that you're being supervised, the probation department felt you weren't complying, then they would file a written charge in the court saying that. You get a copy of it. You're entitled to have a hearing to be represented by the attorney. And at that time, if the outcome was that you failed to comply, then the court would revoke community control and send you to prison for 36 months consecutive, legally charged plus fine $20,000. You understand that?
Yes, Your Honor.
All right. Now, the charge in count 1 alleges that on or about November 4, 2020, in this county, you and Randy Swisher did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance in an amount equal to or exceeding bulk amount less than 5 times bulk amount, in violation of Section 2925.03A1. And then count 5 is the same offense, I believe. Yes. And it alleges that it happened on November 3. But other than that, it's the same charge, the same method, but a different date, same offense on a different date, in other words. Now, you understand what you've been charged with in each of those counts, what the state said you did, when, where, and how they alleged you did it?
Yes, Your Honor.
You understand the possible penalties?
Yes, sir.
Have you discussed the nature of these charges, the evidence in the case, possible legal issues in the case, possible defenses you could try to raise in trial, possible outcomes of the trial with your attorney?
Yes, Your Honor.
Are you satisfied with his competency and advice?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Are you taking any prescription drugs?
Just blood pressure medicine.
Okay. Have any threats been made to get you to plead guilty here today?
No, Your Honor.
Now, on page 2, there are several sentences that are printed in bold, type, and underlined. They read as follows. Defendant shall enter plea guilty to count 1 and count 5. State will dismiss remaining counts. State defense will argue sentence. Defendant agrees to cooperate fully in prosecution of the co-defendant. Defendant agrees to pay back money as part of the plea agreement as follows: $625, joint several of Randy J. Swisher, and $250 per month. That's your understanding of the agreement?
Yes, Your Honor.
Does anyone promise you anything other than that to get you to plead guilty here today?
No, Your Honor.
You've got to promise that if you plead guilty, you'll receive a particular sentence.
No, Your Honor.
Okay. Now, do you hold any license or certification from any state agency, state government agency, or any occupational or professional?
No, Your Honor.
Right now, under the law, you have certain rights you must understand before I can accept a guilty plea. The first is you have right to counsel. Mr. Kirk's been appointed to represent you, but not simply to work the case out, to provide any defense that could be available to you under the law that you wish to provide. So if you decide you do not want to plead guilty, he'll still represent you, he'll defend you, including a trial if that's what you want. Do you understand that?
Yes, Your Honor.
And under the Constitution, you have right to jury trial in this matter, Mr. Swisher, in which 12 people will be selected from a group of citizens from this county, summoned for jury duty on your trial date. After they were selected, the evidence will be presented, and then the judge will instruct them on the law, and then they will decide by a unanimous verdict, all 12 have to agree, as to whether or not the state proved your guilt by proof beyond reasonable doubt. Now, if you did not want to have a jury trial, but you did not want to plead guilty, then you can waive in writing, and that means to give up have a jury trial, and in that case, you would have what's called a court or bench trial, meaning that instead of a judge hearing the evidence, a jury hearing the evidence, a judge would hear the evidence, the judge would apply the law, the judge would decide whether or not to state proof of guilt or proof beyond any reasonable doubt. You understand that?
Yes, Your Honor.
Right now, under the Constitution, you have the right to confront the witnesses against you and to cross-examine through your attorney. What that means is that the witnesses against you have to come to court and testify in front of you and your attorney and anyone else is present. After the prosecutor is done asking questions, your attorney can ask questions, which is called cross-examination. The purpose of that would be to bring out evidence that helps your side of the case. You understand that?
Yes, Your Honor.
Now, under the Constitution, Mr. Swisher, you have the right to use the power of the court. The power of force witnesses to come to court and testify for you, just like the state. So if you have witnesses you're not certain going to come in voluntarily, you request a court-issued court order, that's a subpoena, and that forces those people to come to court and be able to testify, even though they don't want to be here, which is the same way the state witnesses are required to come to court. You understand that?
Yes, Your Honor.
And under the Constitution, you have a privilege against self-incrimination, which means you cannot enforce give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make that decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way with any person. No one's even allowed to comment about it, except in one situation, and that is if there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Just give me a second.
Yes, sir.
Yeah, I got all the sales to the county, that's not what's insurance. So, yeah. So. Good. All right, sorry about that. One kind of problem. All right, now, under the law, you are presumed innocent of this charge until proven guilty by proof beyond a reasonable doubt on every essential element of the offense charged in each case, in each count, I should say. So, you're not required to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to prove anything and put up any evidence at all at trial, because the burden of proof on these two charges is on the state of Ohio. They must prove your guilt as to each essential element of each offense by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, Your Honor.
All right? Now, originally you entered a plea not guilty. Not guilty plea denied the allegations in those two counts, denied actually all counts, and denied you committed any crime, and it exercised or invoked all the rights I just described. Now, if you change your plea of not guilty to guilty to these two counts, then it is the opposite of a guilty plea in that it will admit the allegations in each of those counts, and then admit that they're a crime, and that you committed that crime. And that plea will waive your love as to those two counts, all of the rights that I've just described for you, except the right to have an attorney. You always have the right to have an attorney no matter what your plea. But with that exception, your plea will waive your love, your right to have a jury or court trial, waive your love, your right to confront witnesses against you to cross-examine through your attorney. It will waive your love, your right to use the power of the court to compel or force witnesses being in court to testify for you, the same as the state. It will waive your love your privilege against self-incrimination, because if you say you're guilty, that's what you find you guilty. It'll waive your love your presumption of innocence, because if you say you're guilty, then the state's not required to prove that you're guilty. It'll also waive your love any right to file an appeal that you think you could have had up until this point in the case. Now, if I sentence you the maximum sentence, for under certain circumstances, you can file an appeal, but that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, Your Honor.
And you are a U.S. citizen,
Yes.
and you're entering into this agreement voluntarily.
Yes, Your Honor.
Right, now, do you have any questions about either the charges or the possible penalties?
No, Your Honor.
You understand?
Yes.
Do you have any questions about the plea agreement?
No, Your Honor.
You understand?
Yes.
And again, you understand the recommendation of the state, or that the court could sentence you to prison for this offense, because there's no particular sentence recommended.
Yes, Your Honor.
Okay. Do you have any questions about the constitutional rights of the claim?
No, Your
You
Honor.
understand those?
Yes.
Any questions about the plea of guilty, what it means, what the consequences will be at the end of that here today? You understand that?
Yes.
Can you speak to Mr. Kirk about anything else before we go any further?
No, Your Honor.
Have any questions about anything I've explained to you here today?
No, sir.
Then is it your decision to withdraw your not guilty plea, plead guilty to counts 7, 1, and 5 in accordance with the terms of the agreement that we've just gone over?
Yes, sir.
All right, then as to count 1, which alleges an on or about November 4, 2020, Island County, Ohio, you and Randy J. Swisher did knowingly sell or offer sell methamphetamine, a Schedule 2 controlled substance amount equal to or exceeding bulk amount less than 5 times bulk amount, violation of section 2925.03A1, a third-degree felony, carrying possible prison term of between 9 and 36 months in the increments provided by law, a fine of up to $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
And as to count 5, which alleges the same offense except that it occurred on November 3, 2020, otherwise the same charge, the same penalties. How do you plead?
Guilty.
Thank you, please see. The court finds on this day in open court that the defendant's fines involved his constitutional rights and made a knowing, intelligent, voluntary waiver the same pursuant to Rule 11. Plea is accepted. Order 5. Defendant is found guilty of counts 1 and 5. Third-degree felonies is charged in those counts. Counts 2 and 4 dismissed. The matter is referred to the probation department for pre-sentence report to include assessment for substance use disorder and or mental health assessment. Sentencing hearing will be September 22nd at 1 o'clock. And bond will be continued. All right. Is there anything further from the council?
I'm looking for put on an order he brought from the facility.
There's folks over here, you can talk with me here.
Before you go back.
Yeah, we agreed to do the jury room at full.
Thank you, Your Honor.
You meet with him in the jury room?
Yeah.
Yeah, okay, there's plenty of room in there. So you go ahead and go on back there and sit at one end and he'll sit at the other end. Do you have Mr. Hall as well?
I do.
Joshua Hall?
I've read your
Ma'am. This, yeah, come on, Mr. Hall. Case number 21 CR 047, State versus Joshua James Hall. Present for the State's Assistant Prosecuting Attorney Adam King. Present for the Defendant Attorney Dennis Burke, and you are Joshua James Hall.
Yes, Your Honor.
The Hall is charged with receiving stolen property, a 4-3 felony. This is a final pre-trial, and let's see. Trial date is set for August 26th. Now, Mr. Hall, I've been presented with a plea of guilty form, which indicates you're going to withdraw your not guilty plea, plead guilty to the charge in the indictment. This is a 3-page form that the prosecutor's office prepared, and on page 3 there's a signature line. It looks like it's James Hall, and her sentence reads, I enter this plea voluntarily. Did you sign this agreement?
Yes, Your Honor.
When did you sign this agreement?
Today.
And did Mr. Kirk go over that with you before we signed it?
Yes, Your Honor.
Did you understand that it was an agreement to plead guilty, which means there won't be a trial? The next step in your case will be a sentence.
Yes, Your Honor.
And I know that you've been in prison or brought back for the hearing. Do you have enough time in your mind to fully consider this matter before making this decision?
Yes, Your Honor.
You don't feel you're rushed or pressured in any way into doing this?
No.
You're entering into the agreement to plead guilty voluntarily?
Yes.
All right, the agreement states that, again, as I indicated, you're going to plead guilty to count 1 under 2913.51 revised code, a 4-3 felony. Further states that the maximum sentence in this case is 18 months. The minimum could be 6 months if prison term is imposed. There's also fine available of $5,000. You understand that?
Yes, Your Honor.
Now, you are serving a sentence currently. Are you facing any other felony charges anywhere else?
No, Your Honor.
Well, if you're convicted of this offense and sentenced to prison, that term can be ordered to be served consecutively to the sentence you're now serving, which means on top of it, so that extend the time you'll remain in prison. You understand that?
Yes, Your Honor.
So you're not on community control or post-release control or parole or anything like that for a felony? Post-release control?
I'm on community control in Claremont County.
Okay. Well, if you were convicted of this offense, I don't know when that offense occurred, when we put on paper, but if this offense occurred while you were on community control in that case, could be a violation which would result in that being revoked and being sentenced on that case, and that could be added to be consecutive as well, but any sentence from this court and the current sentence you're on, you understand that?
Yes,
Yeah. Now, not required to sentence you to prison for this offense. I can impose what's called community control or non-prison sanctions, and that means instead of going to prison, you can be put under the supervision of a probation officer for a period of 5 years, under the term set by the court, and if during that period of time the probation department felt you were not complying, they could file a written notice of that with the court, give you a copy, there'd be a hearing, you'd be entitled to have an attorney. If the outcome of the hearing was that you failed to comply, then at that time, you could be sentenced to prison, revoked and sentenced to prison for 18 months and fined $5,000. You understand that?
Yes, Your Honor.
Right now, the charge alleges that on or about January 14 of this year in Hyden County, Ohio, you did receive, retain, or dispose of certain property being a motor vehicle as defined under ORC section 4501.01, the property of another above none, and that you, knowing or have reasonable cause to believe, said the property obtained through permission of theft offense, which would be a violation. Section 2913.51, receiving stolen property for felony, as we just talked about. Now, do you understand what it is you're charged with, what the state said you did, when or how they alleged you did it?
Yes, Your Honor.
You discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible outcome of the trial with your attorney.
Yes, Your Honor.
And are you satisfied with his advice and comments in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Are you taking any prescription drugs?
No.
Have any threat that may get you to plead guilty here today?
No, Your Honor.
Now, on page 2, there are several lines printed in bold and underlined, and I'll read those as follows. Defendant shall enter plead guilty to the indictment. State defense is joined to recommend 9 months incarceration, consecutive to the term of incarceration defendant is currently serving. Defendant shall pay restitution to Douglas Nunn in the amount of $4,720.29. Is that your understanding of the agreement?
Yes, Your Honor.
And has anyone promised anything other than that to get you to plead guilty here today?
No, Your Honor.
Now, the matter of sentencing is up to the judge, not the parties. So even though there's an agreement that this should be the sentence, once I've heard all the information submitted to me, if I think that's not the correct sentence, I could sentence you to a term of as much as 18 months in prison and also fine you $5,000. You understand that?
Yes, Your Honor.
Is there any dispute as to the restitution, Mr. Burke?
I presented that number to my client, he did not have any dispute with that.
Okay. And have you discussed this matter with the victim, and that's the amount that he is agreed to? That's correct. Okay, now, do you hold any license or certificate from any state governmental agency, any kind of an occupation or profession?
Like a plumbing certificate?
No, that'd be from a trade organization, like a nurse assistant or STNA or an engineer or surveyor or anything like that.
No.
Okay. Now, you have certain constitutional rights you must understand before I can set the plea from you. First of all, you have a right to have counsel in this case. Mr. Kirk was appointed to represent you. That's not simply to work the case out, but provide any defense that might be available to you under the law that you wish to provide. So, if you decide that you do not want to plead guilty, you'll still have counsel to represent you to defend you in this matter, including a trial, if that's what you want. You understand that?
Yes, Your Honor.
Right, now, under the Constitution, you have a right to have a jury trial in this matter, Mr. Hall, when 12 people be selected from a group of citizens that live in this county, were summoned for jury duty on your trial date. After they were selected, the evidence would be presented, and then they would decide by unanimous verdict, between all 12 and have to agree on whether the state proved you guilty of the charge. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you could waive in writing, which means to give up your right to have a jury trial, and in that case, you would then have what's called a quarter bench trial, meaning the judge would hear the evidence instead of the jury. The judge would apply the law, and the judge would decide whether or not the state proved your guilt by proof beyond reasonable doubt. You understand that?
Yes.
Right now, under the Constitution, you have a right to confront witnesses against you in open court and to have your attorney cross-examine them. So what that means is that the witnesses have to come to court and testify in front of you and your attorney and anyone else is present. After the prosecutor is done asking questions, your attorney will ask questions. That's called cross-examination. And the purpose of that would be to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
Right, under the Constitution, you have a right to use the power of this court to compel or force witnesses to be in court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily at your request, the court will issue a subpoena, which is a court order. That would force them to come to court to testify if you wanted them to, even though they didn't want to be here, which is the same way the state's witnesses are forced to come to court. You understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't. You decide. If you decide not to testify, the fact that you did not testify not be used against you in any way or any person. No one's even allowed to comment about it, with one exception. That is, if there is a jury trial and you did not testify, the judge does instruct the jury then that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, Your Honor.
Under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. That means that the burden of proof isn't on you to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence at all in your defense. You can, but you're not required to. But whether you do or not, the burden of proof will remain upon the state at trial. Prove your guilt by proof beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. You understand that?
Yes, Your Honor.
Now, you originally entered a plea not guilty, Mr. Hall, which denied the allegations in the indictment, not committed any crime, exercised or invoked all the rights I just described. If you change your plea from not guilty to guilty, that is the opposite of not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you're the one who committed that crime. That plea waives and gives up all the rights I've just described except the right to have an attorney. You always have a right to have an attorney no matter what your plea. With that exception, your plea of guilty waives or gives up the right to have a jury or court trial, waives and gives up the right to confront witnesses against you, cross-examining your attorney, it waives and gives up through your attorney. Waives and gives up your right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state. Waives and gives up your privilege against self-incrimination. Because when you say you're guilty, the state is not required to prove that you're guilty. It waives and gives up your right to require the state to prove your guilt by proof beyond reasonable doubt. Because if you plead guilty, they don't have to prove your guilt. Subject you to being sentenced immediately by the court, which is what's likely to happen. And it also waives and gives up any right to file an appeal that you think you could have had up until this point in the case. Now, if I should sentence you to the maximum sentence, or under other limited circumstances, you could file an appeal, but that would have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes, Your Honor.
And are you a U.S. citizen, Mr. Hall?
Yes, Your Honor.
All right, now, do you have any questions about the charge or possible penalties?
No, Your
You
Honor.
understand?
Yes, Your Honor.
Questions about the plea agreement?
No, Your Honor.
Understand?
Yes, Your Honor.
Have any questions about the constitutional rights I've explained to you?
No.
You understand it?
Yes,
Any questions about the plea of guilty, what it means, what the consequences of that plea will be if you do it here today? Do you have any questions about that?
No, Your Honor.
You understand?
Yes, Your
Would you like to speak to Mr. Burke about anything before we go any further?
Honor. No, Your Honor.
Do you have any questions about anything I've asked?
No.
Or I'm explaining?
No, Your Honor.
Okay. All right, then this is your decision, Mr. Hall, to withdraw your not guilty plea, plead guilty to count 2, subject to terms of the agreement we just went over.
Yes, Your Honor.
All right, then as to the charge, which alleges that on or about January 14, 2020, this county, you did receive, retain, or dispose of certain property being a motor vehicle, as defined in ORC section 4501.01, property of another Doug Nunn, said Joshua James Hall, no one had reasonable cause to believe obtained from Commissioner Defense in violation of section 2913.51 of the Ohio Revised Code, a 4-degree felony carrying possible prison term between 6 and 18 months and a fine of $5,000. How do you plead?
Really?
Thank you. Be seated. Court finds on this day in open court that it's applied his constitutional right pursuant to Rule 11 and made a knowing, intelligent, voluntary waiver of those pursuant to Rule 11. The plea is accepted for the file. Defendant is found guilty of the charge in the indictment as set forth in the plea agreement and in the indictment. Given the defendant's purpose of the prison term, there's one recommendation for sentencing imposed. Court's going to go ahead and proceed with the sentencing. All right, anything further from the state?
Only was contained in the video.
Mr. Kirk?
Thank you, Your Honor. Would ask the court to follow the agreement. My client is currently serving a term of incarceration in Adams County Authority Prison. It does have a prior felony record according to the discovery. He did cooperate by pleading in this case, and would ask the court to follow that agreement. Thank you.
For Paul, anything you'd like to say?
No, Your Honor.
Well, you have, how old are you?
35.
35. And how many numbers have we got now?
This is the third.
Third. And you have quite a few felony convictions, some of those, I think, currently. Is it breaking and entering, burglary, forgery, safe cracking, and theft, attempted escape law in this county. Theft out of Adams County. Alright. Well, Mr. Hall, since you cooperated and you're already serving a prison term, we're going to follow the recommendation of the plea agreement. So it is a judgment for the court that you be and are hereby sentenced to serve a term of 9 months incarceration, which term will be served secondly to the sentence that you're currently serving from Adams County. Court finds that this is a separate course of conduct from the Adams County offense, and that one single prison term will not adequately reflect the seriousness of the offense. It is not, court sentence is not disproportionate to the seriousness of the crime. Also, the extensive criminal history justifies a second sentence being imposed with protection of the public because you seem to steal and break into places which endanger the public. And further, the parties have stipulated to this sentence being second. You will be given credit of 5 days, which includes 2 days back in March, and then from yesterday, versus I guess on the 9th until today, and that you get credit for that. Now, upon completion of this sentence, the adult parole authority has the option, if they choose to exercise it, which under post-release control supervision for a period of up to 3 years. They don't have to do it; it's optional, but they'll decide. If they do, we supervise the terms they set by a parole officer. If you commit any violations of those rules, then they can return you to prison. They can serve additional time of up to 9, well, actually in this case, half of your prison term, which would be 4.5 months for one or more violations. But if it's a felony, then in addition, whatever sentence the judge can impose in a new case, the judge can also sentence in this case to an additional period of 1 year, whatever time left on that period of post-release control, whichever is greater, and if that occurs, that will be served consecutively the sentence in the case. We're also to make restitution, or to pay restitution to Douglas Nunn in the amount of $4,720.29, and make that restitution through the victim witness, victim escrow account, and paying the fees associated with that. And also, Mr. Hall, that obligation doesn't go away. If you serve all your time, it's not something that you can declare bankruptcy on, and so you're subject to being brought back before the court until the case is until it's paid. And if the court finds you unable to pay it or refused to pay it, I should say, and had the ability to pay it, then you could be put in jail for contempt for that. You also would pay the court costs, the judge grant execution order, and if that, if you did not pay the rate, do that, pay according to the plan, then the clerk can collect that through various means, including levying bank accounts, wages, or any other assets you may have. That doesn't apply to them upon completion of your prison term, not while you're in prison, after you get out of prison. Then the court authority to a service fee for that each item work in and out of the second for each item work, reduce your judgment by that amount until paid. All right, so anything further, counsel? Your man back to custody, thank you. All right, Melanie Bowline.
All right, Brother Charlie.
Case number 20 CR 259, State of Ohio versus Melanie Ann Bowline. Present for the state is Mr. Prosecutor King. Present for the defendant is Attorney Danielle Witt. And are you Melanie Ann Bowline? All right, Bowline, you have been charged with grand theft of a firearm by the grand jury. This is a final pre-trial. We have a trial set for August 26th. I've received a plea of guilty form, which indicates you're going to withdraw your not guilty plea to the charge. This is a 3-page form, the prosecutor's office prepared, and on page 3 there's signature lines, and near the top of the page there's a sentence that says, "I enter this plea voluntarily," and immediately below that there's a line on which it appears there's a signature of Melanie Bowline. Is that correct? That's what I'm looking at?
Yes, Your Honor.
And when did you sign this agreement, Ms. Bowline?
Yes, Your Honor.
Was that at jail?
Yes, sir.
Was your attorney there when you signed it?
Yes, sir.
Did she go over with you and explain it to you and answer any questions?
Yes,
And you understood when you signed it, it's an agreement to plead guilty, which means it's not going to be a trial, and the next step in your case would be a sentencing hearing.
Yes, Your Honor.
And have you had enough time to fully consider this matter before making this decision? Do you feel you've been pressured or rushed in any way into pleading guilty?
Yes, sir.
All right, now the agreement states that you're going to withdraw your not guilty plea and plead guilty to the charge, which is grand theft of a firearm under section 2913.02A1 of the Ohio Revised Code, the third-degree felony. Further states that you understand that the maximum state prison term could be 36 months in prison, and a minimum would be 9 months in one's imposed. There's different levels in between those two ranges. There's a fine available of up to $10,000, and there's a presumption you should be sent to prison, although it's not mandatory. You understand that? Are you facing any felony charges in any other jurisdiction? Are you currently on probation, parole, or post-release control for a felony in any jurisdiction? Now, under the law, if you should be sentenced to prison and serve a prison term that was imposed, and once that is completed, the parole authority, as part of the sentence, could choose to keep you on what's called, whichever was called post-release parole supervision for a period of up to 3 years, which means they would set down certain conditions that you would be required to comply with and be supervised as to the compliance by a parole officer. If they felt that you were, or if they found that you were in violation, then they could return you to prison even though you served the entire term set by the court for an additional period of up to 9 months for one violation, but there is a limit of half of the prison term for one or more violations. However, if you violate by committing a new felony, then in addition to whatever sentence the judge in the new case imposed upon you, that judge would also be authorized to sentence you in this case for committing a felony while under post-release control for an additional period of 1 year, whatever time's up on the period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new your case. You understand that? Right now, under the, well, let me read this charge here. Charge alleged on or about September 11, 2020, in Highlands County, Ohio, you did first deprive Howard Rose, the property owner of the property, and maintain exert control over said property with a high point 9mm handgun. Said property being a farm is defined in LRC section 2923.11 without consent of Howard Rose, the owner of person on question give consent. In violation of section 2913.0281 of the Ohio Vice Code. So that's the charge of grand theft of a farm, the 5th-degree felony, carrying the possible prison, I'm sorry, 3rd-degree felony, carrying possible prison term between 9 and 36 months and fine $10,000. Now, Ms. Bowman, do you understand what it is you were charged with, what the state said you did, when, where, how they let you did it?
Yes.
You have to speak up.
Yes, sir.
Okay. And did you consult with your attorney regarding the evidence in the case, possible legal issues in the case, the possible defense you might try to raise a trial, the possible outcome of the trial with her?
Yes, sir.
Are you satisfied with her advice and confidence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time? Do you take any prescription drugs?
No.
Have any threats been made against you to plead guilty?
No.
Now, the agreement states on page 2, there's been 3 lines that were printed bold and part of them have been marked out, indicating they don't apply. So I will read those that do. Defendant shall enter plead guilty to the indictment. State defense will argue sentence. Defendant agrees to make full restitution. Is that your understanding of the agreement?
Yes, sir.
Can't speak up, please.
Yes, sir.
Has anyone promised you anything other than this case you plead guilty here today?
No.
And no one's told you that if you plead guilty, you'll get a particular sentence?
Yes, sir.
Okay. Do we know what the amount of restitution is? Yeah.
No restitution.
There's none? Okay, government will recover it?
No, victim is not seeking restitution.
Okay. Right. Now, do you hold any license or certificate from any state, governmental board, or agency of any kind of occupation or profession?
No, Your Honor.
Right, now you have constitutional rights to understand before I accept a guilty plea. First, you have right to counsel, this witness to represent you, not simply work the case out, but provide any defense that's available to you in the law which you wish to provide. So if you decide you don't want to plead guilty, she'll still represent you, defend you, provide any defense that is available to you under the law which you wish to provide. You understand that?
Yes, sir.
Right now, under the Constitution, Ms. Bunline, you have the right to have a jury trial with 12 people be selected from a group of citizens from this county, summons for jury duty on your trial date. After the 12 people were selected, the evidence will be presented, the judge instructing on the law, and then they will decide by unanimous verdict, all 12 have to agree, whether or not state prove your guilty. Now, if you didn't want to have a jury trial, you didn't want to plead guilty, you waive in writing, that means to give up. Right to have a jury trial, in that case, you would have somebody for the bench trial, instead of the jury hearing evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not state prove your guilty, but prove beyond reasonable doubt. You understand that?
Yes, Your Honor.
Right now in the Constitution, you have the right to confront the witnesses against you, cross-examine them, and open court for your attorney. So what that means is that the witnesses against you have to come in court and testify in front of you and your attorney and anyone else in front of you. After the prosecutor done asking questions, your attorney asks questions. That's called cross-examination, the purpose of which is to bring out evidence which helps your side of the case. You understand that?
Yes, Your Honor.
Now, in the Constitution, you have the right to use the power of the court to compel or force witnesses being forced to testify for you, just like the state. So if you have witnesses you're uncertain whether to come in voluntarily, jury requests court issues court orders, called a subpoena, and force those witnesses to come to court if they able to testify for you, even though they didn't want to be, which is the same way the state's witnesses are required to come in and testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, Ms. Beaumont, you have privilege against self-incrimination. That means you cannot be forced to give evidence in this matter anytime, including trial. No one can ever make you testify. The prosecutor can, the judge can. You decide. If you decide not to testify, the fact that you did not testify, not used against you in any way by any person, no one's even allowed to comment about it, except in one situation. That is, if there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Right now, under the Constitution, you have a presumption of innocence. Means you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. So, the burden of proof is on you to prove you're not guilty simply because you're indicted. In fact, under the law, you're not required to present any evidence in your own defense of trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt, but prove beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof is known under the law. You understand that?
Yes, Your Honor.
And under the Constitution, when you when you enter a plea not guilty, you deny the allegations of the indictment, deny you committed any crime, exercise all those rights I just described. If you change your plea to not guilty, that is the opposite of the not guilty plea. I'm sorry, change your plea to guilty, it's the opposite of not guilty plea. The guilty plea admits that the allegations in the indictment, admits that they are a crime, and that you committed that crime. And that plea gives up all the rights I was just described for you, except the right to have an attorney. You always have a right to have an attorney no matter what the plea. That exception, your plea of guilty, wage gives up your right to have a jury or court trial, wage gives up your right to prompt witnesses against you, cross-examine for your attorney, wage gives up your right to use the power of the court to subpoena witnesses to come to court to testify for you, the same as state. Wage gives up your privilege against self-determination because you're not saying you're guilty, that's what you find you guilty. And wage gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court if I decide that's the right thing to do. And it wage gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if I sentence you a maximum sentence, or other limited circumstances for filing an appeal, that would have to be filed within 30 days of your sentencing after being filed. You understand all of that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
And do you have any questions about the charge and possible penalty?
No, sir.
You understand?
Yes.
Have any questions about the constitutional rights of the claim?
No.
You understand?
Yes.
Have any questions about the plea agreement?
No.
Understand?
Yes, sir.
Any questions about the plea of guilty, what it means, what the consequences of that be if you enter here today?
No, sir.
You understand?
Yes.
Anything you'd like to speak with Ms. Wood about before we go any further?
No.
It's your decision then to, do you have any questions about anything on the claim?
No, sir.
Now, is it your question, is it your intention to, decision, I should say, to withdraw your not guilty guilty
Yes.
to the charge, when confirmed, agree with this time?
Yes, sir.
And as of the charge, which alleges that on or about September 11, 2020, in Huntington County, Ohio, you did with purpose to deprive Howard Rose owner of his property, not only obtained jury control over said property, with a high point 9mm handgun, said property via firearms, defined in ORC section 2923.11, without consent of Howard Rose, and other person authorized to give consent, violation section 2913.0281, a charge of grand theft of a firearm, third-degree felony, with possible penalty between 9 and 36 months, and fine of $10,000. How do you plead?
Yes.
All right, thank you. Court finds in, and in this day and open court, defense provides all for constitutional rights, may no intelligible fair way of saying percent of 11, please accept the court file, and it is found guilty of the charge. The court orders a pre-sentence investigation, bond will continue, sentencing will be set for September 22nd at 1 p.m. Anything further, counsel?
Hang on.
All right, thank you. All right, that's the Sowers. Case number 21 CR 086, State of Ohio versus Dustin Sowers. Appearing on behalf of the state, Prosecutor King. Appearing on behalf of the defendant's attorney, Dennis Kirk. You're Dustin L. Sowers.
Yes, sir.
Sowers or
Salaries.
okay, right. All right, Mr. Sowers is charged with great possession and great traffic offense with felonies. This is not a pre-trial. We have a trial set for August 26th. I know I said this on a fairly short schedule because it was rained and no, actually, it wasn't. Anyway, Motion is from, Mr. Kerr indicating that he feels he has a conflict, with, one of the witnesses in this case, because he represented one of the witnesses in this case, it appears that case. And, Mr. Sauer, because of that conflict, Mr. Kerr could represent you, kind of gets it both ways. If he uses information he gained from that, witness while he's representing you, then he's guilty of a offense there. Violation, rule violation, I should say, of professional conduct, and it would also potentially be a conflict for you, because then you wonder if he really tried hard because he represented the witness, so he's kind of, that gets it both ways, he can't get out. There's no way he can, I believe, can let him, continue to represent you. So I'm going to grant his motion to, withdraw, are you aware of any other attorneys might have conflict?
I'm not sure off the top of my head, Your Honor.
This is just one incident, so I'm assuming that must be the only witness that might be represented by somebody. But for the time being, then I'll appoint Attorney Jake Wagner to represent you. I'll have to be standing right over there. Mr. Wagner saw with you, and Mr. Wagner is set to the 26th. You probably will file a continue to grant that, since he should get in the case at equal time to prepare. We can talk to you about that. If the case continues, that does waive the trial time. And since you're out of bond now, that's not a big issue. It's 270 days to arrest, any days you spent in custody of 3 for 1. But because of this, that's a reason to continue to push it out, and it doesn't count. So just so you understand that. Okay? So I see Mr. Wagner, where I've given contact information and giving you his, so you can talk to him. We'll leave the case on the docket right now, but if you file with Mr. Wagner, I'll grant it, and we'll schedule it, and you go ahead and continue to see the professional part. Now, the one thing, talking about that, one thing that will concern me a little bit here is you're testing positive for some substances. It says you did enroll in FRS, and you are taking FRS.
Yes.
Okay, when did that start?
I started, I've been in there a little over a month, maybe.
Okay. Well, I see one of the things you tested positive for, yesterday was gabapentin. You track that.
Then my mother had it, her ibuprofen on it, and
You
I
took
took
it.
it out.
Okay. All right. Well,
I scheduled I was going to talk to my counselor at FRS this evening about further treatment, maybe adding on another day, or I got individuals.
you've been tested positive since July the 1st, 9th, 21st, and then again on the 10th. On the 10th, it was only gabapentin. This time, at least that's one thing. But that, again, is something you shouldn't be taking. Although I'll say this, I took it for several years for back problems, and I don't understand why people take it, because people do it, sleep.
It does the same thing as my mother.
Yeah, you don't need to be doing that, so, make sure you comply with FRS and, whatever else they decide to do. All right, thank you. All right. Okay, Seth Wilkes.
He pled earlier, that's,
Oh, yeah, okay, he's out, okay. Then let's see who we got here. We got,
Mr. Hartman.
yeah. Yeah, that's actually set for sentencing. They apparently said that's because it is for that application. Basic things they send up to me that I don't need to see, and I need to see something, then I don't. And then we find out about it a month later. Oh, government. All right. Dale Ham versus John W. Hartman. Case number 21 CR 105. Present for the state, Assistant Prosecuting Attorney Adam King. Present for the defendants, Attorney Jacob Wagner. And are you John W. Hartman.
Yes, sir.
Department charged with theft by deception and theft by deception from a person protected class. This is final pre-trial, second trial, August 26th. Now, before I address the motions filed, has been seeking discovery provided by the state. And did you get yours in yet, Mr. Wagner?
We did, just the deadline, Judge.
Okay, right. And other than the continuance, are there any other pre-trial motions?
No, if I may, concerning the continuance, Your Honor?
Just let me ask you before I turn it over to you, is there a written payout?
Yes, I think we got a result.
All right. Now, we have a motion to continue, so go ahead.
If I may, sir, I apologize. Your Honor, we've got a result. There is some money involved. I guess just the court's apprised of the whole situation. There's roughly, I'm gonna ballpark, maybe $17,000 here in restitution. We just need to get all of that fine-tuned and ironed out. It's a 2-count indictment. I don't want to get myself caught inside the 2-week window because one count's going to go away, I believe. I anticipate a plea. No, there will be a plea. So I don't know if the court would just want to set it for a plea date or set a jury trial date and get me Marcia beforehand. It's not going to be tried. I don't want to waste your time. We'll have a plea here next week, Your Honor.
Okay. All right, well, I'll go ahead and continue the trial. I won't send anything other than the plea. You can see Miss, see if I don't have a calendar.
I can set it up.
So let's check with her. So I'll just reschedule the trial, which is set for August 26th, I believe.
Yes.
And we'll reset it for the jury trial on September 23rd at 8 a.m. And then get a doctor time next week, get the plea and then let's see our way out.
Okay, sir. Thank you, Your
All
Honor.
right, get in the filing and take it tomorrow. Good, just take it over there too.
Thank you, sir.
All right, do you have any other cases?
That's it, Judge.
All right. All righty, I saw Mrs. Parker there a minute ago, she's ready.
I can yell for you.
She's got the shoes. And also Mr. Ames, not till 3. Okay. You can tell Sarah that we'd like to get these cases done State of Ohio versus Donald B. Hughes, President of the State, Prosecutor Nick Rader. Those on behalf of the defendant is Attorney Sarah Barger. You are Donald B. Hughes.
Yes, true.
And Mr. Hughes is charged with grand theft of motor vehicle as a fourth degree felony. This is a first pre-trial. Final pre-trial set on the 1st of September, and the trial is the 23rd. I see the state provided discovery and a bill of particulars. And I don't see yours yet, not filed yet.
No, it's sitting right here. I just got to see
That's
it.
all right, you do by the pre-trial. Do you anticipate any pre-trial motions?
None this time.
Okay. Has there been a written plea offer provided?
There has.
Is your client aware of Ms. Barger?
Yes, Your Honor, I'm going to go over it with her after we leave here today.
Okay, all right. Are there any other matters we need to discuss at this time?
No, Your Honor.
All right, then, we'll see you back here on, the, 1st of September. All right, and just, make sure you report information as you're required to. All right, thank you. And, all right, do you have anyone else here, Ms. Barger?
They're not here yet, Your Honor.
All right, 'cause I have a log jam 3, we had to run a hearing last minute here. Case number 21-CR-113, State of Ohio versus Josh Costa. For the state is Assistant Prosecutor King. For the defendant's attorney Crossing. If you're Joshua Costa.
Yes, Your Honor.
Mr. Costa has been charged in an indictment, legal count indictment, and aggravated assault and other traffic-related offenses. First pre-trial, second first, trial date 7/23. And I know this case, the previous case, when this was pre-indicted on discovery and so forth, was done in that. So is there any other discovery needs to be done in counsel? And
Discovery's completed, the state, no, nothing further.
Okay. And no pre-trial motion.
Yeah, Your Honor.
Okay. And I understand it's plea offer, or you're likely to this case get resolved.
It's my understanding that final pretrial will likely be clean.
Okay. All right. Okay. Anything else then to be discussed?
I don't know.
All right. See you back here on the first, Mr. Cross. Thank you.
Thank you, Your Honor.
Mr. Hill called and he is unable to get a ride. So I told Marcia to tell him that we're going to meet us next week. He has to be here by 4 o'clock tomorrow for patient. I also explained over to tell him that in the event that wasn't possible, that we did offer a free shuttle from jail to court and mission work so that he would have he could use that service in the future. Court. So we'll see that. Yeah, okay. Hey, what's your name again?
Drinking.
Oh, you're Mr. Hayes? All right. Just see if you can find us our whole question. We're going to do the, are you doing the Zoom hearing on the case tomorrow?
And it is.
All right.
Recording in progress.
Okay, Mr. Ring, is your client there with you?
Yes.
Okay. All right. This is case number 21-CR-24, State of Ohio versus Aaron D. Ludwig. This hearing being conducted by Zoom. It was based on a motion. A couple of motions were filed, one on Monday and one yesterday. And actually, I guess the other one was filed on Friday, but I was out of town, so I didn't see it for Monday. And so the matter set for a trial in the morning. Mr. Collins and Collins, prosecutor's attorney for office by Zoom, and Mr. Ring, the attorney for the defendant, and Mr. Ludwig are also present. And can you show me Mr. Ludwig's face there so it'll be in the record?
Okay, yes, no.
Pardon?
Yes, I can do that.
Okay, thank you, Mr. Ludwig. All right. So actually, there's a third issue too, which is the inspection of medical records, which I have been able to complete today. So I can also address that. So the first issue is motion was filed by the state on the 6th to amend the indictment, and I've been preparing the jury instructions, and I saw what the state was doing. The motion is to amend the indictment because the way it reads now, the statute requires that a person be under 13 in order to be, for the defendant to be found or I'm sorry, in order for a defendant to be convicted of 29-702A1 B, person has to be under 13 years of age and not be the spouse. The indictment alleges in all 5 counts that the alleged victim is under 10. So it does satisfy the statute. It does state a defense. The 10-year-old allegation also then means that a person convicted of this would be subject to enhanced sentence of actually life without parole. I think was it 25 to life, 15 to life, life without parole. Those are the available sentences. Is that right, Ms. Collins?
I believe so. I'm not sure that the 15 to life is, but the 25 to life is.
25 and life without. Okay. All right. So in any event, a motion was filed to amend the indictment to add that she was under 13 and under 10. So I know it's kind of seems to be splitting hairs, but in any event, Mr. Ring, do you have anything to say regarding this?
No, Your Honor, I believe that the motion is appropriate. I don't have any objections to it at this point.
Okay. All right. Well, the court then will grant the motion and will add that the defendant, child was under the age of 13 years of age at the time, and that this should be under 10. So that takes care of that. Second thing is that there's a motion in limine filed by Mr. Ring, which really kind of addresses an issue that I don't know what the alleged hearsay is, other than I guess statements of persons, but the only thing I can say with regard to that is as Mr. Ring said, he didn't want to bring, I think the primary reason he didn't want to bring the problem in voir dire, and I don't let the attorneys get real deep into the details of any testimony. They can talk about a little bit of general subject matter or something like that, not as specific. But Ms. Collins, do you understand what it is he's directing his motion to?
I do, but I disagree that it's hearsay.
Okay, well, and that's fine. I can't rule on it until I hear it. And it may
Right,
be
but
admissible.
he also doesn't want me to be allowed to talk about it in opening.
Okay. All right, so then I'll listen.
Jury voir dire is no problem. I know the court's rule on jury voir dire. I would never do anything like that.
Let's go ahead and get out. And what is it specifically, Mr. Ray, that you do not want these witnesses to say? Or you don't want us to talk about what these witnesses might say?
I anticipate that there's going to be testimony from several witnesses, maybe even as many as 5, who are going to testify that the alleged victim made statements to them. I believe some of the statements are alleged to have taken place all the way back in 2013. I clearly believe that they are hearsay, and I don't think that any of the exceptions under 803 or 804 apply. As such, they should be prohibited.
And are these statements where she said that she had been victimized? Is that general gist of it?
Yes.
All right. I see Ms. Collins shaking her head despite the glare. So tell me what you think is different.
I don't disagree that that's what it is, but to blatantly call it hearsay is not. I mean, I think you need to go back to 801 D1 and read the definition of what's not hearsay. And it specifically says if the declarant testifies and then is subject to cross-examination, and there is an implied, and it has been implied that her motive is one of falsification, it's admissible. It's not to prove the truth of the matter asserted, but that this is not the first time she's asserted it. The defense has called into question her motive by their report from their expert. It completely it's clear full of how often children make up allegations of sexual abuse when they find out their parents are getting divorced and things of that nature. So it has been implied now that she's made this up for that purpose. Therefore, this is not hearsay under 801 D1.
All right. Well, let me look at this overnight then, because I haven't had a chance to look at the schedule we've had this week. But I would say that in the event that it's about, as a general rule that the purpose of hearsay rule is to make sure that the declarant is subject to cross-examination, so the statements to be challenged. So
And she
I would say that those would have to
testified
be, if you offer that kind of testimony, it would have to be offered after she testifies.
Absolutely,
And
she
after
will be
the
testifying.
allegation, you know, that if they are bringing up that she never said anything about this before, or that she did it because of a specific reason, because of something that's happening, you know, then it seems to me that those evidence, those statements to show that they were made back then would probably not be hearsay. So again, I'll have to look at that and take a look at that, and I'll make a ruling on that. I'll give you a preliminary ruling on that. Okay. All right, and then in regards to the medical records, one of them was from the Mercer Center, and I believe Mr. Green, you already had those? The Mercer records? Okay. And then there were two other providers. Let's see. Marathon Health. I guess that's something at Adina now, or courthouse. Okay, they're in the courthouse. It looks like. And then Mayor's Cares Counseling. So, and I guess it's hard for me to understand what might be favorable to the defendant, not knowing any of the testimony or facts. But is there, based on the discussion I just heard, is the defense suggesting that this victim, alleged victim, has made up this because of something happening in the home beyond, other than this divorce or whatever? Because my understanding, parents are now separated, and they're separated, and she made a report after the separation.
I believe the separation of the report was simultaneous.
Okay, all right. Well, that's mentioned in the report. You already know about that. So that was the only thing I saw in the Mayor's Cares. Health records. The same thing. It was reported that he left the home. So you're aware of that. So she said something that I think is typical of all children, and that is that she thought he was controlling and to give freedom. So that's probably something we already know. I don't see anything now that would be particularly enlightening, but I have them, I've read them. So in the event that the testimony comes out with something in there that appears to be contradictory, there's something in here, if you're not aware of it, I'll ask if you're aware of it. If you're not, then I'll permit you to use it. Yeah, like I said, I don't see anything in here that's particular. There's not much at all. In fact, there's nothing really about the allegations themselves, other than her treatment from it. None of the details. And there's no embarrassment, I assume. I didn't read those as thoroughly, but I assume we already had those. And part of it was the report from social worker. Again, I assume you've got that tape, that is, all those things. So I didn't look at that stuff. I think everything there is there. So I didn't see anything in here where there was anything like that where they asked for a narrative description of when, where, how, and why. None of that was in these records. So to that extent, I don't see there's anything at all of any use to defend.
She doesn't recant or anything like that.
Pardon me?
And there's no she doesn't recant or anything like that.
They don't even actually discuss it. I mean, it's clear to me that these are treatment records where the therapists are basically just, working on her mental health and making sure that she is fully right, and there's some medications that I can't remember what they are. I don't know if they're related to because there's also some physical health records in there. So, when she had one issue with the prescription for nothing that was relevant to this that I can see. So, anyway, that's where we stand with that. Okay. So I'll see everybody here at 8 in the morning, and then I'll go ahead and look at this issue and make a decision as to what I think preliminarily it should be, and then we'll move from there. So, Mr. Ray, you plan to be here at 8 a.m. in the morning. The jurors will start being here probably about 1:45, and we'll try to get started about 8:45, and we'll have our jury charge at 4 p.m. Anything further, counsel?
No, sir.
All right.
Have a mistake.
All right, thank you.
Thank you.
All right, I'm gonna grab the smart. Hill called and said that he didn't have a ride, but he didn't want warrant. And so Marshall telling us, well, he has been showing up for probation, so he needs to, if you want to continue to next week, you need to get a date with her, really.
Absolutely.
And I also told her to tell us that he should report by 4 o'clock tomorrow. If he doesn't, there will be more issues on for it because I also explained to him that we offer a free shuttle from the jail to the courthouse that she would be able to use because he'll be in jail. So, and we're about to get here. So, I'm not going to talk because he hasn't been here since the 21st of July. So,
I explained that I would ask for a motion for a continuance, but depending on him showing up for probation is whether or not it would be approved.
Well, I'm going to go ahead and we'll just continue and get a new date for the pre-trial and see if he shows up tomorrow. If he doesn't show up tomorrow, we'll do more on Friday.
Okay. Thank you, Your Honor.
You may. All right, case number 21 CR 50, State of Ohio versus Great Manhattan. Appearing on behalf of the state is prosecuting attorney King. Appearing on behalf of the defendant is attorney Sarah Barker. You are Great Matthew Ames. All right, and keep your voice up so we can make sure it's getting recorded. All right, Mr. Ames is charged with aggravated possession of methamphetamine, 53 felony, carpet handling firearms, with no great misdemeanor, and a torture. The defendant filed a motion for intervention in lieu of conviction, and I did receive a report back, which appears to meet the criteria, legal criteria, provided that he had provided proof of his enrollment in a treatment plan, which he had not at the time that Mr. Fulton sent me this report. I did get back to me today at 12:40 from Southern King Valley, a fax which indicates that he made an IOP on 10/9 and 10/10/2022. And she can see in the future. I don't know what that, and it says did well in group. I don't know what that means, because on the front page, there's a message that says, he needs to call me to do treatment plan. So I'm not certain that he is actually accepted. And I haven't had a chance to look at this in a crazy couple of days. Let's see. There was a assessment on the 12th of July. Mr. Odom. they made a diagnosis that would qualify, but, Mr. Hayes, when are you supposed to go back?
I started Monday this week.
You did, yesterday, or day before yesterday?
Yes, and then I went yesterday, and then I was supposed to go today, but I had court, so I got to go back Monday.
Well, the problem here is that this message was sent today, and it says he needs to call me to do treatment plan.
Yeah, I think that would be Denny, the one who did my first the assessment. He's supposed to call and follow up on the treatment plan over the phone because he was on vacation, but.
They are knows who this is from.
Is
But it also says you made the IOP on 10/9/2022 and 10/10. You did well in the group, but obviously that's not correct. It was sent on the 10th of August. Were you in group on Monday and Tuesday?
Yeah.
Well, maybe that's well, I'll tell you what we're going to have to do. We're going to have to continue this until we get this clarified and get that. If we want to take this back in here, King, and let's see about let's see, I'll just do it in Bud Market. And then need to get released to the probation department. You don't have any of this with you, do you? Release? No. Right. When we get done here, you go down to probation with Mr. Archie here, sign a release and information so they can give it to him, so he can call, Mr. Hope call out there and talk to him. Because it may be that, like I said, well, you heard what I read. I mean, obviously, it's not 2022. We've got a date next week. We can get a hearing with Sarah. Well, she's here on this bill too. Because I've got to continue this. There's some confusion in the report from about it. Okay, we'll be here next Wednesday. Are you available next Wednesday afternoon, the 18th?
Yes.
All right, let's do it at 1:30, Mr. Bill and Ms. Mason. All right, so go ahead and do an interview, continue that, and I'll just put in there and then we can tomorrow. So, all right. Okay. Well, now that I read the email or fax I got this morning, and again, I've been visited in my dad used to say, or a paper hanger with a broken arm. So I haven't had a chance to read it. It does say that any of them, that must be who Arbor is. I never heard of Arbor this day. He said you attended on the 9th and 10th of August, so that clears that up. But he is, I know he's a mental health counselor, and I don't know, in terms of what you said, there may be some other sessions we can go to. So what I want to do is just get this clarified. I think you're going to be okay. I think that was just a mistake, obviously, but in terms of having to take treatment plans, so the base that says you need to have work on your treatment plan, so that has to be established so we know what you're supposed to do before I can tell you what you're supposed to do, what you have to do, okay? So we'll be here next Wednesday, 1:30, Bill, give you those. Go with Mr. Argina, and if Mr. Holmes down there, give it to him, or if he's not there, get the release from him, and then give it to him, and then that way they can call and talk to their counselors and get the information right. Okay? All right, thank you. So, still on, man.